right, good morning. As you can see, the panel has been reconstituted. So to my right is Justice Suk-Young Shin. To my left, Justice Christopher Hodgens, and I am Justice Eric Neyman, and we are continuing with the December 1st, 2022 sitting. Calling our second case on the list, docket 21P1122, Commonwealth versus Mejia. We'll hear first from counsel for the appellant, Attorney DeMeo.
Good morning, may it please the court. Christopher DeMeo for William Mejia. So I don't plan to take too much of the panel's time this morning. It's a pretty small case. I did want to respond to a couple things in the red brief and then sort of suggest how the evidence should be viewed holistically, because it occurred to me preparing for argument, I sort of go through the two prongs separately, but I'm going to suggest at the end the panel has to sort of look at it all holistically.
Well, that's actually my first question. Your challenge is solely on the basis of nexus, as I understand it. Lack of nexus to the apartment and lack of nexus to the defendant, correct?
Correct.
Traditionally, though, these cases are evaluated under the Aguilar-Spinelli two-prong test. And I don't see mention of an Aguilar-Spinelli analysis in either brief. So is the answer, we just look at the nexus line of cases and Aguilar-Spinelli we put aside, or is that still part and parcel of our analysis?
The focus here is on nexus, Your Honor. I followed the arguments of trial counsel, which I think in this case was correct to concede that because the tipster was known to the police and because it was corroborated by some video at a subsequent point, he didn't argue the reliability and sort of homed in on the nexus.
It's almost one of those cases where the Aguilar-Spinelli test is less favorable to your client than a totality of circumstances test, isn't it? That's.
Yeah, I mean, I didn't really focus on the reliability of the tip at all. So the focus here is really given what the tipster said and then what Officer Shaughnessy puts in his affidavit. Is that enough? So
is it all under basis of knowledge, or is it something separate from that? Is it the two-prong test, right, of Aguilar-Spinelli? One is veracity, reliability of the tipster or of the information, and the second prong is basis of knowledge. So is this all under basis of knowledge, or are you making a separate argument from the Aguilar-Spinelli test?
This argument follows the nexus cases. It's just simply that to have probable cause that some contraband is in a given location, you need a nexus, you need to believe a crime occurred, which they have, but you need a nexus to the defendant, and then you need a nexus to the place that's desired to be searched. This is purely a nexus type of argument. It's not based on whether this tipster was a good tipster or a bad tipster. I mean, the first prong of it is pretty simple. He said he saw a certain license plate car. So clearly there's nexus. I don't think we can deny that there's nexus between Mr. Mejia and the vehicle because it's got the license plate, but that's not enough. They have to prove nexus to the crime, which was shooting a gun out the window near a building. And there's nothing in the affidavit that says, it doesn't identify him. It doesn't say how many people were in the car. It doesn't say if it was shot out the driver window or the passenger window or the rear window. So that's basically the argument there is it's vague as to who actually did the crime as opposed
But counsel, doesn't the fact that the defendant admitted to the police at the scene that he essentially had exclusive control over the vehicle, doesn't that really kind of answer that question?
Oh, I don't think it answers it. I mean, it helps the Commonwealth certainly, but I mean, this panel sees lots of cases where people are driving around with a car full of people up to causing trouble. So the fact that he was in control of the car and or driving the car doesn't mean that he's the one who fired the gun. If the tipster had said, I saw one guy driving a car, then it would be quite a bit stronger. The second prong is to the apartment, and I think that one's weaker for the Commonwealth for a couple of reasons. So the police show up at the apartment about 90 minutes later. Apparently, it seems like maybe they show up at the housing apartment complex about an hour hour and 5 minutes later, but for whatever reason, they don't get up to the apartment until about 90 minutes later. So that is enough time to hide or dispose of a gun. So the question is, why is that sufficient? Now, Judge Sanders said, well, he didn't know. You would have no reason to hide a gun or to conceal a gun if you didn't know you were under investigation. But I would submit that's just not backed up by the affidavit. The affidavit says the tipster, so the guy who gave he or she who gave the tip was out observing the car when the shots were fired, and it says they followed the Camry for some unspecified period of time. So assuming arguendo now, assuming for the first prong is met, and it's Mr. Mejia. So if it were Mr. Mejia, he would have seen that he's being followed, perhaps. And then even more compelling, I think, is when the police get to the parking lot, they spot the Camry, they start walking towards it, and they hear a beep of it being locked remotely, which suggests that if it were Mr. Mejia, again, arguendo, he's at least vigilant enough to be looking out the window or at the apartment and seeing the police show up and locking the car. So I don't really know how you can...
Could it also suggest he had just gotten home?
I don't know if it would suggest he just got home. I mean, I personally lock the car right then and there when I get home. But in any event, it might suggest probable cause that the gun is in the car. I think I would have a slightly tougher case if they had found the gun in the car. But the obverse of that is it makes it less likely it's in the apartment. But in any event, I guess my point is the claim that he didn't know what was going on, he had no reason to hide the gun, I don't think the affidavit supports that. So those are the two prongs. And I guess the other thing that the Commonwealth relies on the argument that people keep their guns nearby on their person, in their property. I think that's intuitively true for lawful guns. I mean, if I'm the kind of person who has a firearm ID card, I probably keep my gun in a gun safe, locked appropriately. I don't know that intuition holds true for guns that are fired out car windows in the early hours in South Boston. I mean, guns get handed around a lot. I'm sure this panel sees cases where, if you do a Lexus search of gave him the gun or handed him the gun or got the gun from, you pull up a lot of cases. So I'm not sure that principle gets you that far. So those are the two prongs. And then I guess the point that didn't come out in the brief that I would like to stress here is that the Commonwealth has to prove both those things. So the total is sort of less than the sum of the parts. And I'll just pull a number out of a hat, but if there's a 50% chance it was Mr. Mejia, who's the gunman, and it's a 50% chance that the gunman would put a gun in the apartment 90 minutes later, then the odds of both those things being true is 50 of 50, it's 25%. So I think it would be wrong for the panel to say, well, you just squeaked by on prong one, then move on to prong two and say, well, you just squeaked by on prong two, so affirmed. You have to look at it all together because it's their burden to show both of them. So with that rubric in mind, I would ask the court to order that the fruits of the search be suppressed.
Understanding that this is a fact-specific analysis, would you say that Hart, which you cite, is your best case?
Yeah, I mean, I couldn't find anything very close to this, unfortunately, but yeah, that's probably true.
Seeing no further questions, thank you for your excellent argument, and we will now hear from counsel for the Commonwealth.
Good morning, Your Honors. May it please the Court, Bryn Morse on behalf of the Commonwealth, arguing on motion at counsel's table is Attorney Brooke Hartley. We respectfully request that this Court affirm the motion judge's denial of the defendant's motion to suppress the evidence that was found after a search pursuant to a warrant of the defendant's apartment. In this case, there's 4 facts that establish the holistic probable cause to search the apartment. First is that we have an exact match to the vehicle used that the person fired shots out from inside of. Second, that vehicle was at the defendant's apartment an hour after the shots were fired. Third, that the defendant himself was also at his apartment at 90 minutes later when the police knocked on the door. And then fourth, as you picked up on, Justice Hodgens, that the defendant admitted that he had sole possession of the vehicle, and he said that he owned the vehicle as well. That creates a strong nexus between the defendant in that vehicle and the defendant having driven that vehicle and fired the shots from the vehicle earlier that morning. And it also creates a strong nexus between the firearm and it being found in the apartment because the defendant was at that apartment so close in time. This court in the SJC has previously found that, close in time when we're talking about a firearm being found can be as lengthy as a day in Alexis, which we cited in our brief. And that's a substantially greater amount of time that someone has to dispose of an object. But with objects like firearms that are durable, we kind of assume that the court assumes that people are going to keep those. That's particularly true in this case, where the defendant didn't have any reason to believe that the police would be pursuing him. Because, it's not a case where, he used the firearm to actually hit someone or even damage property. It was just shots fired outside of a building. And the police officers in this case were lucky to have an eyewitness who was able to provide them details that led them to Mr. Mejia, but it's not a case where Mr. Mejia would expect a lot of investigation.
So the issue here is whether or not there was a sufficient nexus to establish probable cause. Do we still analyze that under the Aguilar-Spinelli framework?
So I think since my brother didn't challenge the eyewitness's account under the Aguilar-Spinelli framework, that you basically take those facts as if a police officer had seen them. In other words, you take those facts as true.
Does that satisfy both prongs of Aguilar-Spinelli if the informant is not challenged, or is nexus just a different test?
So nexus is an entirely separate question. If my brother had challenged under Aguilar-Spinelli the fact that the tipster is an eyewitness and the fact that many of the observations that he mentioned, including hearing the shots or seeing the shots fired, being picked up by the spot shooter activation, and also the path he described the defendant taking, matching up with video surveillance, like that.
I'm sorry to interrupt, but so you're saying, I was always under the impression that Aguilar-Spinelli is the test to establish whether or not there is probable cause. What you seem to be saying is that Aguilar-Spinelli is the test to determine the veracity and basis of knowledge of the informant. But then we go on to consider additional factors to ascertain whether or not there's probable cause. I'm not sure I've ever seen the test framed that way, but go ahead.
So the way I would think about it is there's lots of cases that establish probable cause without any kind of tipster or informant. And in those cases, you look at the nexus between the crime and the place to be searched, or the object you're looking for in the place to be searched. When you have a tipster or some sort of informant, then for just the information that the informant provides, you look to the Aguilar-Spinelli test in order to determine what weight to give to the informant's information. And so, whereas here, there's no challenge to that, you don't have to reduce the weight or discard it because it's sufficient to meet the Aguilar-Spinelli test.
How do you respond to the argument that your friend made about the inference that people keep firearms on their person or with them is it really only applies to lawful firearms?
So I think that the purpose of having an unlawful firearm is also to have it on your person. I mean, people don't possess unlawful firearms just for the sake of it most of the time. It's for self-protection or to be used in a crime. And for those purposes, you still need the firearm to be close by. And I think that's consistent with this court's previous cases recognizing firearms as being durable objects that even criminals are not likely to discard.
So, counsel, just so I'm clear on this, the trustworthiness of the tip was not raised below by the defense, and it was not, as I'm looking at Judge Sanders' memorandum of decision, it was not addressed in her decision, and it's apparently not being raised now on appeal. Is my understanding correct?
That's correct, Your Honor.
Okay.
Do you agree that, well, I don't want to put words in Mr. DeMayo's mouth because he didn't exactly say this, but are you of the opinion that Hart is the seminal case that leads our analysis here?
So I think Hart can certainly be part of the analysis, but I don't think that it answers quite all your questions. I mean, in Hart, the court certainly recognized that firearms are durable, and I think that analysis applies here. But that case is certainly distinguishable because they were talking about finding a firearm in an apartment 60 days later, whereas here it's talking about finding a firearm in an apartment an hour and a half later, where the defendant, you can infer that the defendant took the car from where shots were fired and drove it to his apartment where it was parked, and then went inside. And so there you have much closer nexus to the apartment. So that's more similar to like Alexis, where there was probable cause to believe the firearm would be in the defendant's apartment a day later.
So in your brief, you concede that the defendant's arraignment history is not relevant. Do you make the same concession with respect to the information about his purported gang membership?
So we don't think that the gang membership is quite the same. So certainly here where there's not any information about why he got added to the gang database, it's maybe like minimally relevant and so not a particularly strong piece of evidence, but we think that it's distinguishable from arraignment history. That being said, though, in this case, the court doesn't need to rely on that gang membership in order to find probable cause because there's such a strong nexus between when the shots were fired and then how that firearm likely got in the defendant's apartment. So, if there's no further questions.
Seeing none, thank you very much. The case was well argued and the case is submitted. Calling our next case, docket 21P988. I hope I'm pronouncing this correctly. Commonwealth versus Byer. Attorney Weber.
Thank you. Morning, Your Honors.
Morning.
Philip Weber representing Mr. William Byer. Mr. Byer's case is here today for 3 different issues. I'll begin with the testimony from the DCF worker, Meredith Gach. Her testimony essentially amounted to additional first complaint testimony. Testimony was basically that she received a report of abuse from the complainant. And I find that this is the most similar to case Commonwealth v. Stukic. I'm probably mispronouncing that, so my
I
apologies.
always pronounce it Stuckich, but I'm confident that there are a number of pronunciations that are incorrect. So,
Well, it's a good thing there's numerical citations as well. In which that case, it states that the Commonwealth should not elicit testimony that a complainant complained to other people other than the first complaint witness, even in the absence of the details of the conversation, as it basically amounts to a parade of multiple complaint witnesses, and that a jury would likely assume that the complainant repeated the substance of the accusation. And in this case...
Was this raised below?
It was not raised below, and I do apologize for not specifically stating that in my brief, but this is, it was not preserved error, so it would be under substantial miscarriage of justice. However, I think that it still would rise to that level here, especially considering that this case is in large part, if not entirely, a credibility issue. The defendant's case did amount to stating that the complainant, his daughter, was lying about what had happened. Now, the Commonwealth...
Before you get to prejudice, so there was some discussion before the DCF worker testified about the purpose of her testimony. And the prosecutor says the purpose is to show that when confronted with the allegations, the defendant refused to turn over the victim's electronic devices. The judge admitted the testimony for that purpose, and there was no objection. So are you saying that was error, that it was not independently admissible for that purpose?
Yes, Your Honor, that is indeed my contention.
Why is that?
Well, because the idea that he didn't turn over the electronic devices, the supposed idea behind that was that it would show some type of consciousness of guilt. But I would argue that it is not evidence of that. I mean, not turning over electronic devices shows essentially that he was either shocked at the accusations, that he didn't want to give over electronic devices, especially as I don't recall there being any inculpatory evidence even being on these electronic devices.
But he turned over her other belongings, right? He just would not turn over her phone or whatever it was. So why isn't that relevant, at least, to show that he thought that there might be something inculpatory on the device?
Well, it might be that he simply drew a line there as electronic devices are expensive, maybe he didn't want to turn them over. I mean, I don't want to speculate too much in regards to that, as there's nothing on the record to show the exact reason why he didn't, but I stated I don't believe...
Isn't that what makes it relevant for a jury to make that determination?
Well, I would argue that it wouldn't be because, unless I am mistaken, I don't believe there was any inculpatory evidence on those devices. If there had been some smoking guns, some big message on there, that would certainly make things in a different situation. But if, in other words, it's to not want to turn over something that ultimately doesn't have any significant value, doesn't show I would say does not show a consciousness of guilt. It shows that, I mean, one thing that was presented in the trial is that the defendant didn't like dealing with DCF. Just in general, he talked about having past issues with them, or evidence was presented regarding past issues with them. So not wanting to cooperate with them, if anything, would show more so just that he doesn't like DCF as opposed to a consciousness of guilt in regards to that. In fact, the Commonwealth does try to argue, not just in regards to that, but tries to argue that the Meredith Goss testimony showed other issues, tried to say that that she testified regarding the complainant's sad demeanor, which supposedly would disprove the allegations from the defendant that his daughter was an angry teenager. And I would say that that is a bit of a stretch. Whether or not a person is an angry teenager or not is not defined based on one moment. Even someone who is generally angry can still have a moment where they are sad. Showing that she was sad in one specific moment doesn't suddenly refute things that he's saying in regards to her being an angry teenager. There's also the allegation of the Commonwealth that the testimony showed that she was placed into a residential facility, and that would somehow disprove the defendant's allegation that she lied to try to get away from her father and his restrictive nature. I think that is problematic for a number of reasons, the first of which being her placement in a residential facility shows that she did, in fact, get away from her father. I mean, if she wants to get away from her father, it's exactly what happened. So it doesn't disprove what he would say. And it also goes to this idea, they were trying to argue the idea that, well, if she's placed in a residential facility, she has less freedom than she would have with her father, which I think would be dependent. I mean, freedom is a relative term, what you're allowed to do with one person as opposed to in a residential facility. But even beyond that part of things, there's the fact that why a person does something is based on what they perceive will happen. His daughter didn't necessarily know that she would be placed in a residential facility. The idea is that she lied to get away from him, which, again, would have been achieved by this, but she doesn't automatically know she's going to be placed in a residential facility. She doesn't know what kind of restrictions are going to be in place in the residential facility. That kind of argument essentially assumes that she knows exactly how the system operates, exactly what she'll be allowed to do, not allowed to do, and not to mention the fact that she was only temporarily in this residential facility and then later on was placed with a family that eventually adopted her. So again, it actually shows more so that what she went through would have accomplished the objectives as the defendant was stating. It would have, in fact, gotten her away from the control of her father and placed her somewhere else. So the idea that Meredith Goff's testimony somehow disproves the defendant's case, disproves allegations, I would say very much does not do so. I mean, ultimately, what does Meredith Goff's testimony accomplish? That's really the issue. I don't really think it does accomplish much of anything. It shows that a report was made. Well, clearly a report was made. Even, maybe jurors don't understand every element of the system, but I think even most basic juror understands that you don't go to trial unless there's an accusation, unless a report has been filed.
Okay, so then where's the prejudice?
Well, the prejudice is that it does enhance the credibility of the complainant. It does enhance his daughter's credibility.
Well, except the jury knows that there was a report that was made, and that was essentially what the DCF worker testified, right?
But the DCF worker's testimony essentially enhanced credibility because, and again, this goes to the Stuckey case, this idea that it's another report that this person made to another person. It's essentially another.
If I'm being frank, I have to admit, when it comes to the first complaint doctrine, it's sometimes hard for me to figure out which way prejudice cuts. So in this case, you have some brief testimony from the witness saying that the victim made a report of sexual assault. But then the judge allows in denial evidence that otherwise would be inadmissible, right? So how does that weigh in favor of prejudice?
Ultimately here, I would say that it weighs in favor of prejudice because DCF is an organization that does carry with it credibility. It has a jury.
But the witness was clear that they'll remove a child just based on allegations. And then the judge says, I'm going to let you, defense counsel, put in evidence that the defendant denied the allegations, even though that would ordinarily be inadmissible. So isn't that kind of a wash in a way?
I would argue that it is not a wash. I mean, the defendant obviously denies the allegations. I mean, that I think is essentially just, there's no trial if a defendant doesn't deny allegations. There would be nothing to it. It's over at that point. So anything in
The testimony, if I'm recalling correctly, was that he denied it at the time when he was confronted with them, right?
Yes, Your Honor.
Okay.
And again, I mean, that would be, I mean, if he hadn't denied it when first confronted with it, if he's first confronted with it and said, yes, I did it, that's, talk about pretty much a nail in the coffin there. It's kind of hard to it would be hard to come back from that. So that's a very baseline level of it. But as we have here, we have a jury who's hearing, well, we have an official DCF investigation, and maybe they talk about what would have happened, in regards to if there's a complaint, we remove someone. But regardless, you have testimony from someone who says, well, I take this report from her, and she seemed very sad. And the way the testimony is presented, it is presented in a way that I feel like enhances and bolsters the credibility of the complainant here in the way that the jury would receive it, which is, as stated, incredibly essential here. The credibility is very much a large issue here, which I think ties into all of the issues, but as in regards to one of the other issues, the indictments and the broadness of them.
So before you begin the argument on this issue, number one, I just remind counsel for both parties that there's some partially impounded, or rather there is some impounded material here, so refrain from referencing the specifics of it. And secondly, we have a motion to expand the record before the panel, which has not been acted upon. I did not see that you filed an opposition to that motion. Do you oppose that motion?
I would defer to the court's judgment on that and not take.
I'll take a position.
I'll take a specific position in regards to that.
Okay, so tell us about the notice issue, please.
And without going into too many specifics, essentially the allegations are that there were an offense over the course of 3 years. 8 times, 8 allegations of improper acts over the course of 3 years. Now, as this does come down to credibility, one of the ways that the defendant planned on countering the complaint's credibility was to try to point out and show that there was no way some of these specific 8 instances would have happened by being able to show that either he was not at the home at the time or there was other ways that it couldn't have possibly taken place. But when the allegations become that broad, I mean, I don't think any human being can account for every moment of their life over the course of 3 years.
Were there tools that defense counsel had to require more specificity that she chose not to use here?
There were possibilities in that, and I even considered the possibility of a motion for new trial on the basis of ineffective assistance of counsel. I wasn't certain if it quite rose to that ultimate level, so trial counsel could have done things slightly differently, that much is true.
No bill of particulars was requested, and that we don't know what the response to that would have been, right?
That is correct, Your Honor, but I would argue that while, there are things that could have been done differently. I'm not going to state that this was done perfectly, but I would even say that despite it not being done perfectly, that doesn't erase the significant prejudice that the defendant experienced because of this. I mean, to try to defend 3 years of your life, if someone were to accuse me of improper acts over a course of 3 years, I don't think I could account for all 3 years. I mean,
How is this case different from Kirkpatrick?
And I apologize that I don't know the specific details of every element of the Kirkpatrick case. I do believe I addressed that in my written brief in regards to it, but ultimately this one, the defendant did have the ultimate plan he had was very specific in regards to trying to refute these specific moments, these specific allegations, which again, ultimately became near impossible in regards to that because of it is such a spread out period. I mean, 8 instances over 3 years is so far spread out that I really don't see how an individual could deal with.
But isn't this very common with child victims?
It is something that happens in other cases. I would argue that I think in this case it does indeed cross a line. I mean, to be frank, I think it happens too much, but again, I'm dealing with the specific case in front of us and not all cases. But even so, I would say that I still think this does, cross line in regards to that. It is such a extremely lengthy amount of time for what is a small amount, at least compared to the course of 3 years. If this was an allegation that over the course of 3 years, it was happening once a week, but they only chose to charge him with 8 instances, maybe that would be different, but that's not what happened here. We have the accusation that there's 8 total instances over the course of 3 years. So what would be a somewhat infrequent act, relatively speaking, over the course of such a long period of time, I think is just, it makes it almost impossible to ultimately defend. You'd have to almost prove a negative, and you can't ultimately prove a negative in that type of scenario.
Do you dispute that the police reports and the grand jury minutes were provided in discovery?
I do not, Your Honor.
Okay, thank you.
My time is not. Ultimately, the end, 18 seconds, I don't think it's enough to really launch to a new, so unless I have specific questions from the panel.
Seeing none, thank you very much.
Thank you.
We'll now hear from the Commonwealth.
Thank you very much, Your Honor. Good morning. May it please the Court, Kenneth Steinfeld for the Commonwealth. My brother started his argument today by saying for the first time that part of his claim as to the social worker was that the judge erred when he ruled that it was admissible for another purpose. However, in his brief, he does not even acknowledge that that happened. That's not part of his claim. His brief says that the DCF testimony, quote, served no purpose other than to bolster. And then on page 21, he says, Gock's testimony did not bring to light any new information. So he does not even acknowledge that the social worker testified about his failure to turn over the devices, which, as this Court has noted, and I think the record fully supports, was the obvious purpose, the sole purpose, and the fact that it implicitly told the jury that the victim had complained of a sexual assault to the social worker. That's true in every case in which the SJC and this Court have approved the admission of basically second complaint evidence or further complaint evidence when it is admitted for a proper purpose. Defense counsel never said, no, that's not a proper purpose. He never said, no, wait a minute, this is piling on. Everybody knew exactly what Ms. Gock's testimony was being offered for. So the claim has never been made until right here this morning that the judge erred by deciding that it was admissible for another purpose. As to the second argument, If the members of the court have any further questions on the second claim, I'd be happy to take them, or to move on to the first argument, the adequacy of the indictments.
I'd like to hear about that issue.
If the indictments here, in this case, taken together with the police reports and the grand jury minutes and the CD of the team, I didn't mention in my brief, but I should have, the CD of the team interview was also turned over to the defense. If that is not enough notice, then a whole class of society's worst criminals will never be able to be prosecuted, as this court noted almost 40 years ago in Atkinson, which I would just point out. The judges on that case were Armstrong, Hale, and Smith. Of course, this courtroom is named after one of them, and that one is named after the other, and of course, Judge Smith. So that court was absolutely right, that is the nature of a resident molester and child sexual abuse. This case, there was significantly more information available to the defendant as to what happened, what types of sex acts, where they occurred, when they occurred, and how they occurred, than in that case, and frankly, in a lot of other cases. Had a bill of particulars been sought, there's no evidence, and there's no reason to believe that it would have had anything other than what had already been provided.
Defense counsel, my recollection is, did not raise this issue pre-trial. Is that correct?
He did not.
And at trial, did he say anything to the effect of, Judge, part of my defense is X, and in light of these indictments, I don't have sufficient notice to present that defense?
Not a single word, not a shade, not an idea, it just wasn't at all part of the case. And I think that it shouldn't have been. It is not ineffective in light of Kirkpatrick in many cases since, as Justice Shin has pointed out, he got plenty of information and certainly met the Wolanski standard that he was on notice of the nature of the allegations against him. But if this is not enough...
So on the motion to expand the record, I understand you're saying that the Commonwealth never had the opportunity to put these documents in the record, but on what basis can we consider them?
Pursuant to Rules 2 and 8 of the Rules of Appellate Procedure, which I cite in my... I cited a couple
Could you please refresh my recollection about what those rules say?
Well, 8 is the general about amending, expanding, or changing the record, and 2 is this court can do things to enhance its ability to. It's sort of vague. There's no explicit rule that says that. But I cited 2 cases, Rolandar and Wilson, that apply just in this situation, and I think give this court the power to do it. Neither Rule 2 nor Rule 8 says, provide for this situation, but as I said, these cases allowed something very, very similar to it.
So those cases you cited considered documents, information that was outside of the appellate record?
Yes, the court allowed motions to expand the record to include documents that were not part of it. Okay. And they said pursuant to Rules 2 and 8, and I went and read 2 and 8, and I said, well, okay, if you say so. It's not exactly clear how or why that is, but that is the authority for it, and it took me a while to find it. And I think that it is necessary for this court to understand, to make sense, or to make light of the, to make sense of the allegation that he didn't have enough information to prepare. Well, this court has to know, well, what information did he have to prepare? And I think it's only fair to the Commonwealth that had he moved to dismiss, as in Kirkpatrick, or had he moved for a bill of particulars, as happened in a lot of cases, the Commonwealth would have had an opportunity to put into record the police report. The grand jury minutes are already part of the record, so we have that. And that standing alone is also enough. You don't need to have the police reports, but I think you're entitled to review them. And I did not go back and reread those cases, so I don't have a full...
Which begs a question for me, which is, and I appreciate Mr. Weber's candor in saying that there's no dispute that the police report and the grand jury minutes weren't received. But with that said, does Rule 8 contemplate simply expanding the record by forwarding, for example, police reports to this court, or does it contemplate going back to the trial court and perhaps filing a stipulation of counsel that this information was provided in discovery and then taking that from the trial court and bringing it back here, so it is now part of the assembled record?
The former. Those cases involve motions filed in this court for this court to expand the record to include, and it bypasses entirely the trial court. That's another way to get it done. But I found authority supporting this court's ability, independent of any action by a trial judge, to say, we will consider it. So absolutely, the first thing you said, Your Honor, that you could do it yourself without any action by a trial judge. I'd be happy to go back and to seek permission. I'm not sure how or when I would do that, but I'd be happy to if this court needs to. But if it takes a look at the cases I've cited and the rules, I think it'll find ample authority for what I'm asking.
And this is the Commonwealth's first opportunity to present this information, is that correct? In other
Yes,
words,
yes,
there has
because-
been no motion filed in the trial court, post-trial
No
motion.
idea that the defense maintained that he didn't have adequate notice. And the first thing we would have done, I don't think it's at all speculative, is to provide, well, here is the notice that you got. All of these details, extensive details, are in the police reports, which are fairly long. And one of the police reports goes into extensive detail about what is on the team interview. Basically, you know, it's a narrative of what happens in that. And I think that it's Kirkpatrick, or there is one of the cases that says that in response to a bill of particulars, the Commonwealth provided the defendant with grand jury minutes and police reports, but was not able to provide anything further. So it's clear that in this situation, when a defendant challenges and in that case he did by motion to dismiss, that's what the Commonwealth would have done and lacked an opportunity to do here. But I think that even if it does not take into account the police reports, the indictments themselves have an unusual amount of facts and specific. Each indictment says what specific act was performed, which body parts. And the grand jury minutes, it talks about rooms that they occurred, you know, his bedroom, her bedroom, and the living room, times of day, mostly late at night. One of them occurred on his birthday in 2016, the defendant's birthday in 2016. So he was able not just generally to defend himself against these allegations, but specifically on certain dates of times when some of them occurred, he was able to testify himself, that didn't happen, here's what happened himself. And there's no way that he could have put on a better defense if he had more information. The reality is that kids of that age do not measure time the same way as adults do, and they do not maintain in their memories when things occurred exactly. As this court has no doubt seen, and in the many, many cases I've had, children of that age tend to remember things like their birthdays and what grade they were in. You know, it happened before my 8th birthday, after my 10th birthday. I was just starting 4th grade. That's how children measure time. Not, yeah, it was a Thursday, hot day in August when this happened. That's just not how it works. So for this court to expect the Commonwealth to be able to provide the defendant with that kind of level of detail would be impossible. And as I said, would exclude from the criminal law some of the most serious offenders in society who've committed some of the most serious offenses. And I don't think that is necessary here. I think that the defendant had all the information that he needed to prepare and present a very, very strong defense, actually. And as to the victim's credibility, she did have a lot of credibility problems, as I've noted. Hallucinations, multiple personalities, and she was hearing voices during her own testimony. So the jury clearly had a lot to work with, and yet they convicted on all 8 counts. So they just believed the victim. He has not shown that he would have had an alibi defense, or that he could have found information that he might have used to discredit her. He hasn't made any showing on the prejudice prong whatsoever. In fact, he abdicates entirely his duty to show any prejudice at all. In the 2-page argument that he makes on the subject, and I would point out that both his first and second arguments are just 2 pages each, and I say fail to make adequate appellate argument under Rule 16A9. But that's beside the point. His statement of the prejudice for his lack of notice is overtly speculative. He says, it might have, we don't know. And that's never adequate when a defendant claims that his ability to present a defense was impaired. I have nothing further. If the members of the court have any questions, I'd be happy to take them.
Thank you, Mr. Steinfeld. Very helpful arguments, and the case is submitted.
Thank you very much.
Calling our next case, docket 21P728, Rosario versus Caring Bees Healthcare, and another. We will hear first from counsel for the appellant.
Good morning. May it please the court, I am Michaela May and I represent the appellant, ANAIS Rosario. In North American expositions, the SJC emphasized that petitioning activity includes all statements made to influence or at the very least reach governmental bodies, either directly or indirectly. Likewise, in Rosario 1, this court instructed the motion judge to consider the very broad definition of petitioning activity under the Anti-SLAPP law, including its application to statements outside of governmental proceedings. In the same breath, the court emphasized that Chapter 151B must be construed liberally to accomplish its purposes, and that 151B explicitly protects encouraging others in their exercise of rights under the statute. In Chapter 151B cases, internal complaints of sexual harassment are mandatory for plaintiffs, whether for liability or categories of damages or both. Indeed, an internal complaint was mandatory here. The SJC cases Collegetown and Galakian are clear on these points. If the employee does not complain, they may have no legal remedy or their damages may be reduced. They may also appear incredible when they report that no, they never complained about the harassment they have experienced. Rosario's complaints of sexual harassment are explicitly protected by Chapter 151B. Those complaints are also inextricably connected to Rosario's pursuit of her Chapter 151B claims in the MCAD and in court, and as such, her petitioning activity as well. To hold otherwise would defy Rosario 1 and give harassers and unscrupulous employers a readily available sword of Damocles to hold over the heads of their victims in litigation.
So let me ask you a preliminary question. Do you agree that the statements at issue in this case are those that are set forth at paragraphs 14 through 17 of the counterclaim, those four statements?
I do.
Okay. And, go ahead.
Petitioning activity includes three types of statements relevant
sorry,
here.
I thought you were continuing your answer. Okay.
Oh, I do. I think we agree that it's 14 through 17, and I intend to go through each one of them.
Okay, before you get there, let me follow up. What is your best authority for the proposition that telling a coworker about sexual harassment equals petitioning activity within the meaning of the Anti-SLAPP Act?
Sure. So I think first it's really important to understand the context of the statement. Blanchard 1 and 2 is very clear that the context matters. And in Rosario 1, the motion judge had erred because prior to new SJC authority, she had not gone through the steps of what had happened. You have to look first at the petitioning activity. So it's important to really look at the facts of the particular case. I don't think this court needs to say that every internal complaint or every complaint of sex discrimination is going to be petitioning activity. I think it needs to look at the particular circumstances. So looking at the circumstances of this case, over a period of weeks, the plaintiff observed that Mr. Karangwa, who was the co-owner of Caring Bees, was putting his arm around women, including her, grazing their breasts. He was making lewd comments about her sexual orientation, about her partners. He sent her a sexually suggestive video that I believe we can all agree is not appropriate for the workplace. So Rosario understood that she was experiencing sexual harassment, and she understood that it was illegal. In sexual harassment cases, they don't operate in a vacuum. You need witnesses, And in many cases, as we've seen in recent years, there's powers and numbers. It's very difficult for a victim of sexual harassment to bring a claim with no witnesses and no corroboration.
I don't understand your statement that you're not asking us to adopt a rule that applies in all sexual harassment cases. Wouldn't that be true in all sexual harassment cases?
So I would say that, for example, you need to look at what is the purpose of the petitioning activity. So there's cases where there's a case, and I'm sorry for forgetting the name, but there was a law firm who had a website that was advertising. If she's advertising for her book, instead of petitioning an agency, it's different. But here, her complaints of sexual harassment, both getting witnesses who may have corroborate what happened to her, or who may be, potentially co-plaintiffs, because remember, he's doing these things to other women.
What's the petitioning? You're saying by reporting the harassment to coworkers, that's reasonably likely to reach the MCAD, the police?
Exactly. It's reasonably likely to reach the MCAD and to reach court.
Okay, so then, anytime somebody accuses another person of a crime to someone else, that person committed a crime against me, wouldn't that also be petitioning activity?
So I think if they're trying to get a witness, and remember, these are tailored, narrow complaints, or they're trying to get, potentially a co-plaintiff, which I would agree is a little more restrained.
I don't understand. Trying to get a witness, what does that mean?
So she's saying, I'm experiencing this, I think it's harassment. What's happening, what's happening to you? There's powers in numbers. And Your Honor, the way that the problem of a sham gets addressed is in the second stage. So her motive here doesn't matter. There's no science the court doesn't look at that.
Right, we're looking at whether what she said is reasonably likely to reach a governmental body. And if I'm accusing someone of a crime, let's say falsely, why can't I come in and say, well, I made those statements to a witness so that I would have support for when I file my police report?
I think there's at least two reasons. First, in the context of 151B, complaints like this are mandatory. You don't have a choice. They have to be made in some instances for liability, and in most instances, really all instances, for certain categories of damages.
What's mandatory? It's
complaint
not
of
mandatory to complain about harassment to a coworker.
So first of all, there's two pieces. One, I would maintain that there's more than enough here that her complaint to DeBarros was not a mere complaint to a coworker.
That's not what the judge found.
Well, so I think that this is really a question of law. It is an internal complaint a protected activity.
Oh, no, the judge said, as a matter of fact, your client didn't meet her burden of showing that DeBarros had that kind of authority. And it was your burden at this stage.
So I think there's a few problems there. One, she doesn't need to have that actual authority. I think my client needs to have a reasonable belief. But critically, Section 3A of 151B required this employer to have a policy that says exactly who the complaint is made to and how. Literally, you have to have a phone number. They didn't have that. If you look at the record, their complaint is deficient. Their sexual harassment policy is deficient in numerous ways. So 151B doesn't allow employer to have a see no evil, hear no evil attitude and then blame somebody for filing in the wrong place. Also, this is an 8-employee workplace. The only other obvious person is the person who assaults her. So and the defendants haven't pointed out in their affidavits or otherwise that anybody else should have been the person. On top of that, DeBarros' affidavit doesn't, to my recollection, actually deny that she had HR functions.
So appreciating that the facts and context are critical to this analysis, I want to go back to the question I asked you a few minutes ago, which is, what is your best authority, your best case for the proposition that telling a coworker about sexual harassment or alleged sexual harassment constitutes petitioning activity within the meaning of the Anti-SLAPP Act.
Sure. So I do think this is a very narrow case. I'm not going to tell you that this is not an issue of largely first impression in the appellate courts in Massachusetts. It is. I would encourage you to look at the Superior Court case Mantell, cited in our briefs. There's also numerous other cases where extrajudicial or extra-governmental statements have been petitioning activity. Blanchard was one of them.
Right, so in Blanchard, I believe it was Walczyk, I may be mispronouncing that, brought a defamation claim against the nurses. Sorry, the nurses brought a defamation claim against Walczyk. And in context, the SJC held that the comments to the Boston Globe were actionable because they were likely to reach the DMH, and they were likely to, that was sort of the purpose, arguably, in publishing those statements. But that the statements made by, it was made by Walczyk, in the email to the other employees, the coworkers, was not petitioning activity. So it strikes me that Blanchard might not help your case.
I think Blanchard helps our case, and here's why. So in Blanchard, the problem with the statements to the employees was that they weren't encouraging them to do anything. They weren't saying, we need you to reach out to DCH and your expertise as employees of this hospital and do this. Instead, they're just trying to get them to look at what's going on in a light that kind of benefits them for PR purposes. Here, my client is trying to get support for her claims, for support for people who, I mean, remember, Karen sat next to her. You know, Karen sat next to her when the assault happened. You know, she is the most obvious person, and if this court takes an approach that makes it so that any victim who talks to the coworker sitting next to them about the assault that they have just experienced or about the harassment that's ongoing in their workplace, and they can face a retaliatory lawsuit, you know, it's a really dangerous precedent. It creates a readily available weapon for employers who have more money and more power, and that's the purpose of the anti-SLAPP law.
What if the statements were false?
So if the statements are false, what happens is it's still petitioning activity, but then the burden shifts to the other side, and they can prove through one of two avenues that the statements that were made were effectively a sham.
Right. In Blanchard, I don't think Blanchard helps your case either, because also there was a pending governmental investigation. So there was certainly a stronger argument that any statements were intended to reach that government agency. Here you don't have anything, right? Nothing pending, nothing under consideration. So I'm having trouble discerning from your argument any sort of workable rule that would not make all complaints of sexual harassment or accusations of a crime petitioning activity. So can you articulate some sort of a workable rule? Sure.
So again, I think one component is that these internal complaints are required to bring a robust, thorough, you know, well-supported claim of discrimination. A lawyer is not even going to take a case from a single victim who says, this happened to me, you know.
The rule that you're asking us to adopt is any complaints of harassment or discrimination are petitioning activity? No matter who it's made to.
So I would say any internal complaint of harassment is petitioning activity, and then the analysis moves to the second step.
So the statement to the mother is not petitioning activity?
So the statement of the mother is petitioning activity for a different reason. You know, she's talking to the mother while she's on her way to file the police report. You know, as many victims, she's like, you know, should I do this? Seeking a criminal complaint against your boss is a very scary thing to do. She does what I would say the majority of sexual assault victims would do in this situation. She calls the person most close to her mother, and she's seeking her mother's support to do this. So if you look at the language of the statute, there are three categories of statements that fall under petitioning activity. And one of them, I'm sorry, I'm going to get to the right page of my notes, is reasonably likely to encourage consideration or review of an executive body, here law enforcement. So she's saying, Mom, is this the right thing to do? And the mom says, yes, go ahead and do it. It's, you know, it's contemporaneous with the report. Her mother is encouraging her. Her mother is a potential witness to emotional distress damages and an eventual 151B claim. You know, her mother is a witness of saying this didn't happen, you know, this wasn't, Your Honors, we're talking about first complaint.
So I have a vendetta against a coworker, and I accuse that person of stealing falsely. And I walk around telling all my coworkers that person stole from me. That's petitioning activity.
So that's
I'm going to file a police report. That person stole from me.
So, first of all, if you file a police report, yes, it's petitioning activity.
Police report is.
Yes.
But before filing the police report, I walk around accusing my coworker of stealing from me falsely.
So that's a different situation because it's not a 151B claim. This court has to interpret 151B and the anti-SLAPP law holistically. If you look at the footnote at the end of Rosario 1, basically the court all but instructed the motion judge below to recognize that complaints, internal complaints of sexual harassment are petitioning activity. And a statute under 151B, this court cannot interpret other laws in a manner that is inconsistent with 151B. The stealing from the coworker is different because it's not, it doesn't involve a 151B issue. There's no requirement that you tell other people about it. I think that can be.
There's no requirement in 151B that you tell people.
Well, there is, for example, in sexual harassment cases.
Your time has expired.
Oh, I'm sorry.
Oh, that's okay.
Would you like me to answer the question, or should I finish? All right. So in 151B, for example, there may be no liability for sexual harassment under certain circumstances if you don't file a complaint. And Collegetown, I think, goes to that point. Thank you, Your Honors. We ask the court to reverse the decision below.
Okay. Thank you very much. We'll hear from counsel for the appellee.
Good morning, Justices, and may it please the Court, Pyle Salzberg, on behalf of the appellees, Mr. Karangwa and Caring Bees. My sister started off with the North American case that said 151B protects petitioning activity directed to influence or reach government bodies. And Justice Neyman, you identified those 4 statements, and none of those were directed to reach government bodies. And the anti-SLAPP statute, section 59H, is directed at meritless suits that use litigation to intimidate an opponent's exercise of petitioning and speech. What it is not directed to is to decimate a colorable counterclaim that is brought based on non-petitioning activity. And 59H tells us what that petitioning activity can be defined as. So it has to be an oral or a written statement that is either made before a legislative or a court or an executive body, or a statement that's made in connection with an issue these bodies are already considering. So if there's an investigation of some kind, or if it's an internal investigation of some kind in the workplace, or it's reasonably likely to encourage consideration or review of that issue by one of those bodies, or any statement that is reasonably likely to enlist public participation in an effort to have those bodies consider the issue. None of these 4 statements fits any of those the categories under 59H.
So had the counterclaim included an allegation that the plaintiff had lied to the police when she filed the report, would that have been petitioning activity?
Absolutely. And in fact, in our counterclaims, we made it very clear that any statements that Ms. Rosario made to either the MCAD or to the court or to the police, none of those are on the basis of the counterclaims.
So what if the plaintiff had said to a coworker, he grabbed my, reading from the complaint, he grabbed my vaginal area, and will you come to the police and be a witness, or will you support me in this? Would that have been petitioning activity?
It would not have, and the court only need to look through the 2002 SJC case, Office 1 v. Lopez, which says the motivation to secure a witness for a future activity that might happen, like a petition activity, is not to be considered as a factor under 59H to determine whether it's petitioning activity. So whether, there is an argument of that exact argument has been made in appellant's brief, and the court SJC is pretty clear that says even if it is to secure a witness, the fact that there's no pending investigation, there's no complaint yet, there wasn't even an internal complaint made under the policies and procedures that Ms. Rosario was advised of, and the record showed she signed off on it.
The standard at the first stage actually requires that the statement or the activity, I think the words are solely petitioning activity. Am I correct? Or?
Yes. So,
and yet, though, the case law asks us or tells us in some instances to construe petitioning activity broadly. How do we reconcile those two?
So in this case, it's actually very easy to reconcile because in bringing the counterclaims, we've made it very clear. Look, there were several statements made by Ms. Rosario. The petitioning activity that was before the MCAD, before the police department, that's separate. We're not talking about that. We're only talking about statements that were made to private individuals who had no authority to do anything about it other than gossip in the
So let's say that DeBarros was the designated person in the company to receive harassment complaints. Would that be petitioning? If she had then complained to DeBarros?
If she were. However, we have an affidavit in the record in connection with the 59H anti-SLAPP motion to dismiss where DeBarros says she wasn't. In fact, we have 5 affidavits.
I skimmed it really quickly just now, and I think your friend is correct that it doesn't expressly say she wasn't. It says she's an office assistant.
She's yes, correct. But she says that there were 10 people in the office, including Ms. Rosario and Mr. Karangwa. She did not have any, she had some HR responsibilities, but in terms of whether she would be the person to make a report of sexual harassment, Ms. DeBarros says she was not. Karen Kiminia, who was another coworker, she said the same thing. She said, in fact, an oral statement was made by Ms. Rosario to Martine Philanthrope, who Ms. Rosario herself said, I spoke to her as a friend. I confided in her as a friend. So there's nothing in the record that says that any of these statements made to the 3 coworkers were in her effort to make an internal complaint against Mr. Karangwa. In fact, if we go back and go to Ms. Martine's affidavit, she said on the day that Ms. Rosario was hired, or shortly thereafter, Ms. Rosario said, I know what sexual harassment is, and if I don't get a raise, I'm going to bring a complaint against Mr. Karangwa for sexual harassment. So, again, you look at the whole context as to when these statements were made to her coworkers and to her mother versus the statements that were made to the police, legitimately as petitioning activity, to the MCAD as legitimate petitioning activity, and there's your line to be drawn. Are the statements that were made to the co-workers in furtherance of her efforts to get the legislative body, the courts, the police, the MCAD to take some action on her part to prevent sexual harassment? They weren't. And that's where the line is drawn, because if we start drawing the line to any time an employee makes an allegation, whether right or wrong, to another employee who has no authority to do anything about it or start an investigation or take it up the chain, then 59H will do away with any claim that an employee, Justice Shin, you recognize it, any claim that the employer may have that he or she has been falsely accused. 59H will do away with all those compulsory counterclaims. The only way Mr. Karangwa could have brought these legitimate claims of defamation against her was a compulsory counterclaim in this lawsuit. He has no other choice.
Let me ask you a little hypothetical.
Yes,
it kind of goes back to what seems to be sort of the core kind of SLAPP suit. Let's say we have a developer in town and he's proposing some massive development, and there's a group of residents who are concerned about it, and they're exchanging emails, and in the emails, you know, some residents are saying, boy, I think this is an unscrupulous developer and he's violating the law, and, you know, we really should do something about this. Then the developer gets wind of this email and then files a lawsuit claiming defamation. Would that be different from what we have going on here, where it's sort of a preliminary discussion among people about, geez, we think there's a violation of the law here, we should do something. Is that different than what we have going on here, or is it similar?
Absolutely, it's different because that's exactly what happened in 477 Harrison, which is a case that came out in 2019 from the SJC. And there, the court found that the people who were going to be affected by this development were trying to get a group together to enlist public participation and then take their claim about this, the effect that the development would have on their properties and on their interest in the properties in a public way. So in that case, the court said yes. I mean, even though there was no pending lawsuit or a pending claim against the developer at that point, the fact was these were individuals who were getting together to figure out how they could enlist public participation and then bring a claim against the developers to stop the development. So it's a completely different.
Okay, so you would agree then that sometimes preliminary discussions can be a basis for petitioning activity, just not in this particular case.
Yes, and that's because 59H, in fact, says any statement reasonably likely to enlist public participation in an effort to effect consideration by one of these bodies. And Judge Rosemary Connolly, in the second round, after the appeals court said, hey, go back and look at it and don't assume that the statements are petitioning activity, go back and look at these specific statements to see if they really are petitioning activity. In fact, help the appellee's case, because now she said, you don't even meet the first time around, I assume that you met your burden, Ms. Rosario, but now that the appeals court has said that I need to go through the analysis sequentially, you don't even meet the first burden, the first prong. And so, and in the statement, Judge Rosemary Connolly said, none of these statements that were made to the co-workers, because they were in private, they were individual statements made to her, co-workers separately, they were not geared towards enlisting public participation in any claim that she may have had against Mr. Karangwa and Karen Bees.
So Judge Connolly implied that were she to go further, she would reach the same conclusion on the fair assurance path of the second prong of the test. But do you agree that that we can't reach it, that let's say that we have to decide on the first prong?
Yes, at this point. However, this panel has the benefit of the appeals court's analysis the first time around, where even though Judge Connolly assumed that they were protected, prong one was met, she did go ahead and do the analysis for prong two, which was sham petitioning and the colorable claims.
But she didn't do that on remand.
She didn't, because she said if you fail the first one.
Right, so let's say, just hypothetically, we were to disagree with you on prong one, we would have to remand again, right?
Yes, on the prong one issue.
No, let's say we say this was petitioning activity. We can't then go on and address prong two, right? We would have to remand for the judge to first address prong two.
I don't think you would need to do that, Justice Shin, because the law of the case based on the first appeals court opinion.
Right, but in the intervening 128, if I recall it correctly, we said, hey, there was this SJC decision that said here, that explained further what the factors are to determine whether under the fair assurance prong, right? And so it was remanded partly for that purpose as well, and then on remand, the judge didn't actually cite any of those factors.
She did not, no,
Right,
because she meant that.
And we would review that for abuse of discretion, so wouldn't we have to remand?
Yes, if you disagreed on the first prong.
Right, because we sent it back because we ordered the judge to go through a sequential application of each factor. And since she cut this off at the first stage, there has been no sequential application of each and every factor under the augmented framework, right?
That would be technically accurate, but if you look at Judge Rosemary Connolly's two opinions, I mean, essentially, she does meet both prong one and prong two.
I mean, it seems like she's saying what she would have done, but she doesn't actually apply the factors and say it. That's the problem.
Correct.
Right, okay.
I just have one additional question. I noticed in the record appendix on page 372, the defense counsel acknowledged that the claims in this case were not chilled Does that have any bearing on our decision as far as whether or not this was petitioning activity? In other words, it appears to me that if the petitioning activity as alleged by the appellant is November 2017 through July of 2018, it appears there was no chilling effect during that period, that petitioning activity went on without any hindrance. Does that have any bearing on?
Yes, because she's still able to bring the claims in front of the MCAD, and she was able to bring the claims in a complaint and an amended complaint. Again, because our counterclaims are not based on what statements that were made either to the police, which is that November 15th, 2017 is a tricky date because a lot of things happened on that same day. The statements that were three of the statements were made before the police report was made or before she started the petitioning activity. So that's a little bit of a tricky day for cutting off when the petitioning activity started. And, we're still here. She's still petitioning. I mean, we've still got a case pending in the Superior Court. So none of the statements as part of the petitioning activity are at issue in the counterclaims.
I understand. Okay. Thank you.
And I see my time is almost up if I don't.
Nope. That's it.
No, thank you both. Thank you for your very helpful briefing on what can be a very difficult procedural issue. The case is submitted.
Thank you.
Okay. We're going to call the next case. Docket 22P247, RC International Temp Services, or are we calling that case last, Mr. Speaker? We're calling 6. My apologies. We changed the order, and we are calling docket 22P80, KP versus KT. And I'll remind counsel that this case is impounded, so please refrain from using the parties' names, and please refrain from referencing any impounded material. We will hear from counsel for the appellant.
Good morning. May it please the court. My name is Taylor Henley, and I represent the respondent. In 2018, 2 elementary school girls were playing outside in their neighborhood when one threw a ball at the other. Years later, when the children were 13, one child, the plaintiff, filed an application for a harassment prevention order against the other child, the respondent. The plaintiff used the ball-throwing incident, among other things, as justification for the application. The juvenile court judge issued and then extended twice that order, despite lacking jurisdiction to do so, and despite clear and convincing evidence that the plaintiff's family weaponized the order in its long-standing feud against the respondent's family. The issue in this case is whether the judge should have allowed the respondent's motion to vacate. Before I begin argument, I want to acknowledge and apologize for an error in the notice of appeal. The intention was to appeal both the extension of the order and the denial of the motion to vacate, but that is not reflected in the notice, so I will be focusing.
What do we do about that?
Today, I will only be arguing on the motion to vacate, and so at this point, I think the court is bounded by current case law to only address the issue of the motion to vacate.
Okay. So the extension is not properly before us?
No, I would agree with that.
Okay. On the motion to vacate, the SJC has said several times that a motion to vacate is not a vehicle to challenge the original order. I take most of the arguments in your brief to be challenging the initial issuance of the order. So could you just explain how we were able to reach those issues?
Yes. So I would say, looking at first the jurisdictional issue, jurisdiction can be raised at any time, and that is not something that is waivable in a lower court. So I would suggest that this court can always reach that. Turning to the other issues as to the merits of whether the order should have been extended, I would suggest that the original filing, although entitled a motion to vacate, was in fact a motion to reconsider and vacate. The reason being that looking at the substance of that motion, the substance included a number of arguments that were more
The
appropriately.
motion to reconsider is also not a vehicle to challenge the original order.
My understanding is that it is, Your Honor, and I apologize if I'm incorrect on that.
No, I think the SJC's case law is pretty clear that once an order is extended once, and then there's no appeal, right? But there is an appeal from the second extension, there's no vehicle for challenging the first extension. So after the first extension here in 2021, May 2021, there was no appeal. So from what I understand, we can't review the merits of that order.
I don't believe that Your Honors can review the first extension, no. I do believe that Your Honors can reach the issue of the merits because of the issues raised in the motion to vacate, and the reason being that trial courts can reconsider their own decisions at any time. The judge at the lower court level declined to hear the motion as a motion to reconsider her own previous judgment because she said that the motion was not timely. And in that, she cited what I understand to be Rule 59B, which says that motions to reconsider a judgment must be filed within 10 days of the original judgment. However, looking at Rule 59E, I apologize, looking at Rule 60B, that is a motion considers motions for any type of post-judgment relief. And that would include, I would suggest, a motion to reconsider the original order. And those can be filed within any time that's a reasonable amount of time.
I mean, ordinarily, a Rule 60 motion has to show something has changed, whether it's the facts or the law, or something has changed.
And I think here, the motion, although it certainly does address the merits, it also does address whether something has changed in the weaponization.
Right, but then it's essentially saying the same thing as the motion to vacate, right?
Yes. I would still submit that, although it's certainly most Rule 60 motions might be motions to vacate, the reporter's notes to that rule suggest that it's any motion for post-judgment relief, and so that can be considered here. I do want to bring Your Honor back to the jurisdictional issue, which, as I mentioned, can be raised at any time and is not waivable because it's a matter of subject matter jurisdiction. Incidents that occur before a child turns 12 are outside the jurisdiction of the juvenile court and therefore cannot constitute a basis for issuing a harassment prevention order or extending one.
Was she 12 when the order was filed, the application was filed?
She was 13 when the
So then
application
how does
was
it go
filed.
to the court's jurisdiction as opposed to whether the first act qualifies as one of the 3 required acts? Once the application is filed, she's 13, so the court has jurisdiction.
Yes. However, to issue a harassment prevention order, you must have 3 instances.
Right, but that's
of conduct.
not, I'm having trouble seeing how that's a question of jurisdiction over the case, because she's now 13 when the case is commenced, as opposed to maybe you can't count the first act as a qualifying act because she was too young.
In the juvenile court, Your Honor, actions are punished based on the age at which someone was when they committed the alleged act. For example, in the Laszlo L. case, which I cited to in my brief and which is referred to extensively in my brief as well as referred extensively to the 2018 legislation, the defendant in that case was 11 years old, and the SJC did not say, just wait until the child turns 12 and then you can bring a case against him. Rather, the appropriate age to consider was the age at which the child committed the alleged action. And here, one of the 3 instances, the respondent was either 9 or 10 years old.
But Laszlo was a criminal case, correct?
It was a criminal case.
Okay. Has any case expanded this notion to civil cases?
Not as far as
You're
I'm...
trying to do so here, I understand, but...
Yes, so I'm only trying to do so here, Your Honor, because the 258E statute gives exclusive jurisdiction to the juvenile court. Chapter 258E, Section 2 exclusively gives jurisdiction to the juvenile court for all harassment prevention orders.
So why wouldn't the juvenile court have jurisdiction of actions of children under 12?
Because, oh, I apologize.
Go ahead. In this context was what I was saying. Go ahead.
In this context, because the juvenile court is a court of limited jurisdiction, the juvenile court does not have jurisdiction for conduct committed under the age of 12.
For criminal conduct or any conduct?
For criminal conduct.
Right. And this is a civil case.
That is correct. However, an abundance of case law has extensively discussed the considerable consequences for issuing a harassment prevention order, including Gassman versus Reason, AT versus CR, the cases I cited in my brief, including, oh, I apologize, I don't want to cut you off.
You're not, but I guess my question is, so you're asking us to apply that criminal concept in the civil context to harassment orders. What's your best authority for that proposition?
I would say the first is that Commonwealth versus Dowell, which says that provisions of legislation addressing similar conduct, similar subject matter, must be construed to make a harmonious whole. And here I would say Chapter 258E, Section 2 must be construed in light of Chapter 119, Section 52, which limits the age of juvenile court jurisdiction.
You're saying it's similar conduct as in it's similar to the conduct we would find in a criminal case? Is that what you mean?
For a harassment prevention order, yes, similar subject matter, yes,
Similar subject.
is the quote, I believe. And I would also point to the legislative history of the reform to Chapter 119, as the SJC outlined in Laszlo L. And I want to quote from that because I think it's helpful here. The legislature implicitly declared that the juvenile justice system is not the appropriate forum to address offenses committed by children under the age of 12. And although this is a civil matter, it does have criminal penalties. I also want to address an argument I raised in my brief regarding the results of issuing an order against someone who is either under the age of 12 or someone who has committed conduct that happened under the age of 12 and then they've reached the age of 12.
It could be enforcement issues.
There is, exactly, Your Honor. There are very significant enforcement issues. And so what you'd have here is you could have if you didn't interpret, if this court chose to say that there is no minimum age, there's no jurisdictional bar for a harassment prevention order, then parties would go into court. A judge could issue an order against an 11, 10, 9, 2, 3-year-old, and if that order was violated, nothing would happen.
But if, as here, the child is over 12 when the case is commenced, you wouldn't have that issue.
You would not have the issue in terms of enforcement. You'd still have a sort of bizarre issue where how long ago can you go for conduct and then wait until the person turns 12 or 13. 258E was created to protect victims who could not legally seek protection under 209A. And I think it's important to note that although, as I mentioned earlier, that this was that we are attempting to apply here the jurisdictional issues in the juvenile courts to a civil statute, that is not the case for 209A, which gives exclusive jurisdiction to the district court even for orders that issue under the age of 12. So this is a purely harassment prevention order issue. And there are considerable slippery slope issues here as well. I do want to turn briefly to whether the plaintiff's family weaponized the order, which is another argument that was made in the motion to vacate. A motion to vacate requires a significant change of circumstances by clear and convincing evidence. It also requires that the plaintiff would no longer reasonably fear imminent serious physical harm. Here, there was ample evidence of a significant change of circumstance that demonstrated that the plaintiff and her family no longer reasonably feared imminent serious physical harm. The plaintiff and her mother chose to walk their dog right by the respondent's house and stand right outside the respondent's window on multiple occasions. In fact, the judge confronted and even scolded the plaintiff's mother a number of times for her and her daughter's behavior at the December 3rd hearing on the motion to vacate. This suggests both a complete lack of imminent fear and the use of the order as a weapon to bully and retaliate against a family they so clearly disliked. I want to draw Your Honor's attention to a quote from that December 3rd hearing by the judge. I'm not worried about the 2 children at this point. This, to me, suggests a clear lack of concern for the behavior of the respondent against whom the order had issued. Instead, the real concern was the parents. And I think that's evident throughout all the hearings, but particularly the December 3rd hearing. However, no order was ever issued against the parents. The only person to face consequences for this was the 13-year-old.
So ultimately, the judge, who I think gave a lot more of a reasoning than we normally see in these cases, I thought was very thoughtful, says in the end, you know, I have concerns, but I don't think it rises to the level that you've shown. In order to vacate, you have to show by clear and convincing evidence, I don't think you've met that standard. Isn't that at least in part a credibility determination? And
Yes.
if so, then how do we reverse that?
Under an abuse of discretion standard, Your Honor. That's
It's a credibility. She's heard the evidence, and she says, you know, it just that you hadn't met, not you, but that the defendant hadn't met her burden by clear and convincing evidence. So it's hard for me to see how we can find an abuse of discretion there.
Well, I would suggest that Your Honors have a full transcript of everything that happened. You had, I believe, 4 witnesses testify as to the behavior of the plaintiff and the plaintiff's mother. You had the plaintiff's mother admitting to some of that behavior. You had a whole back and forth between the judge and the plaintiff's mother about where the plaintiff and her mother walk their dog, and why are you walking the dog right by this house here? Aren't there a number of other places you could walk your dog? Why are you choosing this spot? And then I do want to point Your Honor's attention to one of the last things that the judge says at this December 3rd hearing, and I'm paraphrasing here, something along the lines of, I want to be crystal clear that you and your daughter should not be anywhere near the respondent's house, period. She doesn't end with admonishing the respondent, who's the one who had the order issued against her. She ends with admonishing the plaintiff and the plaintiff's family. And undoubtedly, there was a lot going on at this hearing. I think that all of us can agree with that. And undoubtedly, there was some poor behavior. But as the counsel for the respondent said at the hearing, the person sitting quietly throughout that whole hearing was the 13-year-old respondent, and she was the only one facing any consequences for this.
And this order has since expired and not been renewed, correct?
It has since expired.
You're arguing, though, that it's not moot for the reasons in our case law. I do understand.
Yes, under Seni versus Mejia.
See if anyone from the panel has any further questions. Seeing none, thank you very much, and the case is submitted.
Thank you very much.
Calling our final case, 22P247. This time I mean it, RC International Temp Services versus Coliseum Companies. We will hear first from counsel for the appellant, Attorney Adams.
Attorney Babcock.
Attorney Babcock, my apologies, you are listed here. Attorney Adams was on.
In our division of labor, Adams is, Attorney Adams is the brains, and I'm the voice. Most of this is his, almost all of it is his good research and work. So,
Good morning, Justices. Douglas Babcock for RC International. This case is a pretty simple one, both at the Superior Court level and at the appellate level. The complaint is pretty straightforward. Coliseum committed wage theft, got caught doing it by the AG. The AG required them to pay $900,000 of what they saw was $1 million, a little over $1 million worth of wage theft. RC International were the employees that Coliseum committed the wage theft from. The $1 million is far, far short of the amount of money owed to RC's employees. Additionally, Coliseum's remedy for getting caught stealing wages and incidentally also not paying necessary taxes to the state on those wages, was to cut out RC entirely, and then stole all of their employees with no notice whatsoever. RC International.
Well, the merits of this case, though, really aren't before us, right? Right now, this is on a...
Right, but the only reason I mention it is because in the appellee's brief, they indicate that there's a lack of prosecution and that there's no possibility of success on the merits. So they kind of raised that issue in their brief, and I just want to make it clear from the outset that we very much think that there's very substantial. I mean, there's no doubt that there was a theft from RC employees. There's no doubt that RC employees were then converted and became Coliseum employees literally overnight with no notice and zero compensation whatsoever to RC.
The judge dismissed this case at the pretrial conference, and
Yes.
this was also a motion hearing.
Yes.
And
So-
my understanding is that your colleague, Mr. Adams, filed an affidavit,
Yes.
and in the affidavit, he said, among other things, that he had no information, instructions, or engagement. Sorry, he was unable to obtain any engagement, information, or instructions regarding plaintiff's litigation of this matter, has been unable to prepare a pretrial memo. And I guess that begs this question for me, which is, if he and you presumably were unable to file a pretrial memorandum, which is a violation of Rule 16.
Yes.
And I do understand that he moved to continue. How could you move for trial?
Well, so, and thus is our need for receivership, which was the other motion at the time in place.
So let me ask you this question. Is, at the time of the pretrial hearing, when the judge dismissed this,
Yes.
was your ability to move forward on the case contingent on the appointment of a receiver?
It's a good question, Judge. I think...
I love when I ask good questions.
Well, I think from my perspective, as one of the attorneys on the case, I think our ability to go forward on the case certainly would have been impaired without any sort of receivership. I think that Attorney Adams correctly, or we, correctly cite in our brief that our legal obligation as attorneys for the corporation would have required us to proceed to the benefit of the corporation, and we could have done so notwithstanding Attorney Adams' affidavit that there was a problem in choosing litigation strategy. I think
but I want to go back. I'm sorry to interrupt you, but let's go back and put ourselves in the position of the judge.
Yes.
The judge has the motion and affidavit in front of her. It
Yes.
says, I have nothing to go forward on. I can't even file a pretrial memo. And then it says, basically, I can with a receiver, though.
Yes.
I'm paraphrasing.
Yep.
At the motion hearing, at that pretrial hearing, did Attorney Adams ever make any other representation about an ability to go forward without a receiver?
I don't believe so, and I was at that. I was at that hearing, and actually,
and I've read the transcript.
and I presented.
So again, my question is: at the time the judge allowed the motion to dismiss,
Yes.
was your ability, at least as represented to the judge, contingent on the appointment of a receiver?
I would say yes. I would say to fully and effectively represent the client, we need a receiver for the, and again, the reason I say yes, if I can.
We're going to get to the receiver issue.
Right, if I can expound, and because I want to fully answer the question. For example, and again, this is also why I mentioned the strength of the case. We could file a motion for summary judgment and say, based on these things, it's clear that there's liability on behalf of Coliseum. We could even go as far as to say we have, several causes of action on which we are confident that we can prevail, and as a matter of law and with the evidence presented, we can get a summary judgment on those issues.
Was that stated to the judge at that hearing?
I absolutely recall stating to the judge the strength of our case, and that I believe that we could have, that we wanted to proceed on with a summary judgment motion. And I know if I didn't mention it in that particular hearing, it's something I certainly had mentioned to the judge before, because that's been our belief from the beginning. But to the point of your Honor, to fully answer your Honor's questions, it's a good question. I really want to answer it fully. Though we could have gotten that far, then the issue would have become at settlement. Okay, so clearly Coliseum stole and committed wage theft. Clearly they converted these assets. Here's a offer of settlement. That's when we run into a problem. So that's when I think we would need a receivership. So at the moment in time of the motion that was argued before the judge, did we need a receiver at that moment in time? It's hard to answer that question. Certainly, we were going to need a receiver to complete the case. So to take the next step, I don't think we needed a receiver. I don't think we need a receiver, and I think
Then why couldn't you file a pretrial conference report?
Well, so I think the pretrial conference report, from Attorney Adams' perspective, would have included more information and would have also necessitated that kind of arc as to are we going to get settlement in the future? What is, summary judgment?
Witnesses, listing issues at trial, listing witnesses. A pretrial conference report is basic information typically.
Typically, yes.
He said, I can't file anything. So
Right.
I'm having trouble reconciling what you're saying with what was represented to the court that day.
So,
If you get a receiver appointed, if you can meet that standard, that may change things, but
yes, and I think it would. And I'm just trying to, because it was Attorney Adams' affidavit, honestly, about the pretrial memorandum, I'm just trying to think back to the affidavit to try and answer that the best that I can. But from my perspective and what I presented to the judge that day was that my real concern would be not the next step in litigation, but 2 or 3 steps down the road.
okay, but you didn't file anything within the pretrial conference report, which is the first step of the litigation.
So we, at that point, I would say, not necessarily the first step, we had already done some discovery, including deposing Coliseum's.
It's the first step before actually trying a case is what I meant.
Yes.
I understand.
So, and if I could refer back to the case law. So the case law where a dismissal was allowed, and similarly cases where dismissal is not allowed, it's typically where there's no action whatsoever. So for example, a mass broken stone in Buccieri, which we cite as well as the appellee cite, that we're talking about no action whatsoever. In this particular case, there had been a good deal of action taken, including, like as I mentioned, a request for production of documents as well as a deposition and of Greg Dicius, who was being deposed on behalf of Coliseum. So, and that was shortly before the pandemic occurred. So, in answer to your question, we had done and taken many active steps and towards the litigation. And actually, other than COVID, the most significant delay was a 10-month delay by the appellee's counsel in not answering, but instead filing a motion to dismiss, which was denied. So that was kind of the most significant delay.
The dismissal was without prejudice.
Well, yes.
So Why not just refile at the time rather than appeal? I'm just curious.
It's a very good question, and I asked Attorney Adams that. And because the receivership is ultimately going to be an issue anyway, and there had to be an appeal of the receivership order.
The statute of limitations run at the time of the motion to dismiss. It certainly hadn't on the breach of contract claim.
That might be another good question to ask. I should have asked Attorney Adams on that. But my understanding was our main concern was that without the receivership and without a reversal of the receivership order, even if we had gotten some, found someone who could stand in as CEO and hire some sort of, corporate professional MBA type person who can say, I will now take over as officer of the corporation, and we could somehow accomplish that. And thus be able to renew and kind of renew the complaint, then we'd still have the receivership problem.
Your need for a receiver changed, or is the status the same?
It's the same. I mean,
Still need a receiver, you're saying, to pursue litigation?
barring filing with someone who, I can't imagine a scenario, because currently the assets of RC are minimal to none. So we would have to convince as attorneys someone to come in, become an officer for RC, stand in as officer for RC, then give us instructions, do his due diligence, and do all of that for nothing, for free. So that is, I think, a pretty tall order. Versus...
Give you instructions. You mean instructions for trial?
Instructions for trial, or more importantly, instructions on, when it comes to, if there is a possible resolution, with like compensation and some sort of agreement to satisfy it that way. I mean, again, and I don't want to keep harping on it, I only have 2 minutes left, but it's so clear that Coliseum stole from these people. They stole from over 100 different people their wages.
That has appointed a receiver in a factual situation like this? Any case anywhere in the country?
Anywhere in the country, I don't think that we looked as far as afield as anywhere in the country, but the cases that we did cite and the statute itself make it very clear what the purpose of the receivership for, and it is exactly this. It is exactly this purpose.
Just because it's an available remedy under the statute doesn't mean it's appropriate in this situation. And I mean, this seems pretty an unusual situation to appoint a receiver.
I would say it's certainly atypical. It's not what the typical receivership is for.
You review it for abuse of discretion, right?
I would say because there was no written findings whatsoever, and we have no reasoning or findings from the judge, we don't need to use the abuse of discretion standard. But even then, even if we were to use an abuse of discretion standard, absolutely is an abuse of discretion. And again, there's 100 people who got their wages stolen from them, and there's a corporation, RC, who can get money on 2 different theories and give it to those people.
There's no case that says a receiver is appropriate in this situation. How is it an abuse of discretion?
It's an abuse of discretion because the statute makes clear this is exactly what it's for. The statute makes clear that when, as is the case here, there's been a dissolution, and I'll just quote from it. Shall have jurisdiction and equity to appoint one or more receivers to take charge of its effects and its debts, which may be necessary for final settlement and for unfinished business. There's, again, 100 people who want wages or who are owed wages. That's some serious unfinished business. It's exactly what the language of the statute would inquire. I think it's very rare that you have...
Time has expired, but I'm going to give you another minute because we came at you with a lot of questions, so
Thank you.
You can continue.
Thank you. I'll just wrap up by saying I completely agree with you, Justice, that it's very atypical and maybe has not been done before, but that's no reason to deny equity to the people who are owed wages, just that it hasn't been done before. It's clearly within the meaning and purpose of the statute, and ergo, we absolutely should get those people their money.
Further questions? Okay, thank you very much, Attorney Babcock.
Thank you, Justice.
And we'll hear from Counsel for Coliseum.
Good afternoon, and may it please the court, Michael Diulis on behalf of the Appellee Coliseum Companies, Inc., doing business as Bay State Linen. And I'd first like to start by addressing something that was just discussed, and that's the standard of this appeal. And the standard of review on this appeal is...
For which issue?
For both issues is abuse of discretion. And that means that the trial court's determination cannot be overturned unless it's arbitrary and capricious, constitutes idiosyncratic choice, whimsical thinking, or otherwise amounts to an error of law.
Or outside the range of reasonable alternatives under LL?
Correct. None of that is the case here. The trial court's determination was a reasonable exercise of her broad case management discretion in this matter under Rule 41B. This court must afford great deference to that decision and cannot, as RC's counsel essentially asks the court to do, substitute this panel's judgment for the determination of the trial court absent an abuse of discretion.
What if we disagree with you and we think that this really wasn't a 41B2 failure to prosecute case, but it might be a Rule 16 failure to comply with the pretrial, fail to file a pretrial conference report, and failure to move forward in that regard? What then?
I believe that would also be reviewed under the abuse of discretion standard.
Well, it's not clear to me the judge dismissed it on that basis.
I believe the dismissal was under Rule 41B, Your Honor. So the narrow question...
You would agree, though, that dismissal is a drastic sanction?
It certainly is. And
so do you have any case where the court upheld a dismissal, 41 dismissal, where the plaintiff did not miss any deadlines or any court dates?
I believe the Oliver case and the Butchery case, no deadlines were missed in either of those cases. And the court's analysis on a Rule 41B...
Those cited in your brief, I'm sorry?
They are, Your Honor. The court's analysis on a Rule 41B motion is not purely temporal. Simply because there's a long delay or period of dormancy doesn't mean that the defendant is entitled to dismissal for failure to prosecute. And conversely, just because there's been a short period of delay doesn't mean there hasn't been failure to prosecute as well. The court must consider a totality of the circumstances and weigh and balance a number of factors.
What did they do wrong? What did the plaintiffs do wrong here that would warrant dismissal?
What the plaintiffs failed to do wrong, or failed to do here, is manifest an intent to pursue their claims and prepare for trial in vindication of their supposed claims.
How?
The sole principal and owner of RC, who is, for all intents and purposes, the corporation, fled the country in 2018 to avoid criminal charges pending against him for matters related to the relationship of these parties that predated this litigation. From that point on, counsel, Attorney Babcock and Adams, were presumably pursuing the case on their own without any direction or instruction from their client. So while the docket reflects some activity up until late 2018 and perhaps even, or late 2019, excuse me, and perhaps even early 2020, that's a bit misleading because there was no direction from the client at that point in time.
How is that a failure to prosecute issue? That's what I'm not understanding. So they lose touch with you during the, I guess it was around the time of the pandemic, but there was no reason, there's no court-imposed deadline, right, for them. There's no reason for them to be contacting you.
There was no manifestation of intent from that point forward by the client, not counsel, but by the client, to pursue his claims further and vindicate the rights of the corporation.
What if just before the hearing he reappears? Would that have changed the outcome?
I don't believe so, Your Honor.
Why not? It's hard for me to understand how this is a failure to prosecute when I mean, normally you think of missed deadlines, missed court dates, some failure to move the case forward. But if the case is essentially lying dormant for that year and then this guy happens to flee during the same time, maybe that would affect the ability of the plaintiffs to move forward, but it's not a failure to prosecute.
That might be a different case, because then in that circumstance, they may have been able to submit a pretrial memorandum or prepare the case for trial, but that's not what happened here. The client was unavailable since 2018. There was no activity that occurred up until the noticing of a pretrial conference. And in counsel's written submission to the court, which was that motion to cancel the pretrial conference, he admitted not having any contact with his client since 2018.
Let me ask you this, and I apologize for interrupting. Assume everything's the same, except that at the pretrial conference, Attorney Adams and/or Babcock did file a pretrial memorandum, and that's it. They said they didn't make a representation that they were unable to go forward. They just filed a pretrial memorandum and said, "Judge, let's get a trial date."
If that were the case, there would still be a failure to prosecute, because other factors must be considered, namely unfair tactical advantages to the plaintiff or prejudice to the defendant.
Had you sought any discovery that hadn't been provided to you?
At that point, no. However, there would have been no representative of the company available to testify on behalf of the plaintiff.
That happens at trial. That doesn't happen at pretrial. They're the moving party.
Correct.
They have a burden, so they would move to trial presumably and call their witness, and either they could prove their case or not. And if you needed that witness, you would presumably subpoena that, and or try and you might have to go through a difficult process, and then you would make a motion before the judge making the argument that you're now making. But how can you make that at the pretrial conference? That doesn't strike me as failure to prosecute. Assuming, again, that they had complied with the pretrial memorandum and had indicated they could move forward.
Right. In this case, it's a failure to prosecute. I guess you're hypothetical. If they had submitted a pretrial memorandum, then there would have been no violation of orders of the court or
and represented that they could move forward.
That would be a very different case, Your Honor.
So their error was in asking for a continuance of the pretrial?
They actually requested to cancel or, in the alternative, continue the pretrial conference.
So is that so unreasonable that a drastic sanction of involuntary dismissal was warranted? I mean, what if they said, hey, give us 2 months to see if we can locate our client, and then we'll move forward? Is that so unreasonable?
They could have done that, but they didn't, Your Honor, and I submit that I don't think the result would have changed, because they hadn't had any contact with their client since 2018 and presumably had been attempting to contact him throughout that entire course of time.
But I'm just so let's say they said, we're going to try to find him, and so we want to continue this pretrial for some period of time. Would it have been appropriate for the judge to have dismissed the case right then and there?
I don't think so, Your Honor.
So what did they not do?
It's the unavailability of any representative for RC that requires dismissal under these circumstances, because there was no practical means by which the case could have proceeded forward.
Can't you imply from their request for a continuance that perhaps they were going to try to locate their client and move forward? I mean, I guess I've never seen a failure to prosecute because someone asked for a continuance. I've never seen that.
Mm-hmm.
Maybe there is a case like that. I just haven't seen one.
I'm not aware of one either,
Okay.
Your Honor.
So just so I understand this, so the essence of your claim is that it's the absence of the principle from the country that really demonstrates the absence of any manifestation to prosecute the case. Is that right?
That's precisely right. since that individual left the country, there was no manifestation of an intent to pursue the claims any further and to prepare the case for trial, despite what counsel may have done on their own accord and by their own volition.
I mean, wouldn't the prudent course have been for the judge to continue the pretrial for some period of time and said, if you cannot produce your client or prepare a pretrial memorandum, I'm going to dismiss the case at the next date?
I don't believe so, considering that counsel had ample opportunity to do that for a number of years prior, had notice of the pretrial conference, and presumably had been attempting to make contact before that, and still, by the time the pretrial conference arose, hadn't been able to or hadn't attempted to make contact with the principal.
Aren't dismissals for failure to prosecute normally with prejudice?
I believe so, Your Honor.
Why did the judge dismiss it without prejudice?
That's a very good question, and we requested in the lower court that the dismissal be without prejudice, especially given the totality of the circumstances, that there would be no way for the case to go forward, and I believe there are statute of limitations issues as well.
Do you have any insight as to why the judge said
I do
without
not.
prejudice? Okay.
If I may turn to the receivership issue, which I don't believe this panel needs to reach, assuming the motion to dismiss for failure to prosecute is affirmed. Now, RC's briefing focuses almost exclusively on the legal authority trying to establish that remedy. We don't take issue with the fact or don't dispute that it's a recognized remedy under Massachusetts law. However, RC fails entirely to articulate either at all or persuasively why they're entitled to that drastic remedy, which has been called a remedy of last resort under the circumstances that were presented before the lower court. The statutes that they cite to merely establish two things. One, that a dissolved entity may carry on certain activities to wind up its business affairs, and two, that under certain exceptional circumstances, a receivership might be called for to assist in those winding up activities. But the issue here is really the propriety of that remedy under the circumstances and facts presented in this case. And contrary to what is in RC's briefing, where they say the trial court has no discretion, that it should be automatic or compulsory, that's not what the SJC has said in the seminal case of Falmouth National Bank dealing with receivers in the late 19th century, which is still good law today, where that court says the appointment of a receiver rests in the sound discretion of the court. And as Your Honors pointed out during my brother's presentation, RC cites to no case law, whether in this jurisdiction or abroad, that supports the type of receivership that it's seeking here, which is a receivership essentially over itself to allow it to continue a litigation midstream under circumstances where certainly a judgment hasn't entered, and I'd submit is not reasonably likely to enter in that party's favor. And the typical case would be where a judgment creditor, or even a simple contract creditor, moves the court for the application of a receiver over the judgment debtor or simple contract debtor. And in that case, courts have, again, in certain exceptional circumstances, appointed a receiver provided there was no less drastic remedy available. That's starkly different from the situation that we have here. The other potential application of a receiver could be in an administrative in re proceeding that's a non-adversarial proceeding where it's brought simply to wind up the business's affairs. And that's what MGL's Chapter 156D, Section 14.32, which is cited in RC's briefing, contemplates. That's the appointment of a receiver in a judicial proceeding brought to dissolve a corporation. Again, that's not what we have here. And finally, I'd like to address one point that's in RC's briefing about counsel's so-called ethical obligations to pursue a receivership. I'm not aware of any rule of ethics or any law that requires counsel to move for the drastic receivership remedy, which imposes a significant burden on the court in terms of resources and time overseeing a receivership. Particularly, there's no ethical rule in circumstances where There's no other shareholders, owners, or other constituents of the corporation out there that would be adversely affected in the absence of a receiver. Again, the sole owner and officer was, for all intents and purposes, the corporation. And if counsel truly was worried about corporate creditors of RC, as I believe is stated in their briefs, then this state's insolvency laws and bankruptcy proceedings provide an adequate remedy or recourse there. It's certainly not compulsory for the judiciary to impose
Your time
this
has
drastic
expired,
remedy.
but I will give you additional time, as I did your brother.
I will rest on my briefing from there, Your Honors, unless you have further questions.
Any further questions? No, thank you both. Attorney Babcock, I apologize for calling you Attorney Adams. That's who I had on my list, but thank you both for your arguments, and the case is submitted, and that concludes our session.
Thank you very much.